Chairman Smith, Ranking Member Conyers, and other members of the committee, I thank you for the opportunity to testify before this distinguished body today on an issue that is at the heart of our Constitution's structure, the essential duty of the legislature to ensure that the executive branch does not exceed its rightful authority. Now, at the outset, I want to point out I don't want to wade into a dispute between the chairman and the ranking member. My purpose here today is to discuss the concerns of the founding generation, to discuss the concerns embodied in the Constitution itself. The founding generation, including the authors of the Federalist Papers, made clear that they understood, based on their colonial experience with Great Britain, that there was great potential for abuse in the chief executive. Consequently, the Founding Fathers put together a document that put numerous checks on executive power to make sure that this power wouldn't be used excessively, or as they often referred to it, abused. Alexander Hamilton referred repeatedly in the Federalist Papers, most notably in Federalist 66 and in Federalist number 77, to what he himself referred to as an abuse of power. He used that term sometimes not just as a legalistic term to describe what might have been a perhaps criminal violation of law, but also to describe an excess of power, one that might be offensive to the legislative branch. He made clear that it was not only the right, but also the duty of the legislative branch to make sure that any such excesses of power were responded to appropriately by the legislative branch in order to protect the legislative branch's own prerogatives. So, again, our discussion today about executive power is a timely one. In recent decades, we have witnessed the executive branch claim for itself more and more power. But this trend has arguably reached a new disturbing level under the current administration. President Obama has treated the Constitution's separation of powers principles as if those principles were matters of convenience that may simply be ignored when they happen to get in the way. Rather than cooperating with Congress or respecting the Constitution's separation of powers, he has, in many instances, chosen to go it alone. And in the process, he's expanded the proper boundaries around executive power, boundaries that were put in place for a reason. The framers were very well versed in the dangers of excessive government power. With the abuses of King George III fresh in their minds, they drafted the Constitution so as to provide each branch with the necessary means and the personal motives to resist the encroachments of the other branches of government. Among the means the Constitution affords Congress to check the President's power and ensure that he faithfully executes his responsibilities is the right to withhold consent to the President's judicial and executive branch nominations. Article 2, Section 2 of the Constitution provides that the Senate must give its advice and consent to the President's appointment of such persons. Congress also has an essential oversight role with respect to the executive branch. When executive officials make mistakes or exercise poor judgment, internal procedures will sometimes, but not always, remedy the problem. Inherent in our Constitution's system of checks and balances is the need for Congress to have access and visibility into the executive branch's administration of our laws to help ensure the proper functioning of the federal government. Congress must also ensure that the executive branch does not usurp legislative power. Article 1, Section 1 grants Congress all legislative powers. When an administrative agency makes broad legislative rules, or when it enacts regulations that contravene federal policy as embodied in federal statute, the executive branch violates Article 1 of the Constitution. I'd like to briefly discuss just a few instances in which President Obama has exceeded the Constitution's boundaries. On January 4, 2012, President Obama made 4 controversial executive appointments. Even though the Senate had refused to give its consent for one of those appointments and had no opportunity to consider the others, the President asserted that these appointments were made pursuant to the Constitution's Recess Appointments Clause. Even though the appointments occurred at a time when the Senate did not consider itself in recess, and even though the Constitution expressly grants the Senate and Congress generally the power for each body to set its own internal rules, including its own schedule. Even more troubling, in justifying his unconstitutional recess appointments, the President relied on a Department of Justice Office of Legal Counsel memorandum, which asserted that the President may unilaterally decide when the Senate is and is not in session for purposes of the Recess Appointments Clause. President Obama's appointments were no different in kind. They were indeed different in kind than previous recess appointments made by any president of either party. It's often controversial when a recess appointment is made, but this kind of recess appointment, one made when the Senate did not consider itself in recess, is not one of those appointments. No president has ever unilaterally appointed an executive officer during an adjournment of less than 3 days as determined by the Senate's own rules. Neither, to my knowledge, has a president of either party ever asserted the power to determine for itself when the Senate is or is not in session. Another example of President Obama's refusal to respect the Constitution's separation of powers occurred when he improperly asserted executive privilege in response to a legitimate congressional inquiry related to Operation Fast and Furious. Now, courts have recognized two different types of executive privilege. There's the executive process privilege and the presidential communications privilege. The deliberative process privilege does not apply in this instance with respect to the Fast and Furious investigation because government misconduct, here misleading Congress in a February 2011 letter that asserted that the administration did not allow gun walking, is the basis for Congress's request for documents. And the privilege disappears altogether when there is any reason to believe government misconduct has occurred. That's according to the standards set by the U.S. Court of Appeals for the District of Columbia Circuit. With respect to the presidential communications privilege, the executive branch may assert that privilege only for communications made in operational proximity to the President, communications at a level close enough to the President to be either revelatory of his deliberations or to pose a risk to his advisors. Accordingly, either high-level administration officials were involved in misleading Congress or the White House is improperly asserting executive privilege. President Obama again abused executive power when earlier this year he announced that he would stop enforcing key provisions of the Immigration and Nationality Act. Specifically, he issued an executive order providing that illegal immigrants who meet certain qualifications may apply for work permits. President Obama sought to justify this abuse of executive power by claiming that he may properly rely on the notion of prosecutorial discretion. But prosecutorial discretion is something different than what happened here. That refers to the concept that the government may or may not be able to enforce the law with respect to each and every instance of a violation of the law. What happened here isn't that. Here the President outlined entire categories of individuals who, while violating the law, may nonetheless receive the express blessing of the federal government to remain here and work in violation of our laws. One of the reasons this is disturbing is because Congress had, in fact, specifically considered legislation that would have had this effect. That legislation was rejected by Congress. It didn't pass. The President nonetheless decided to go it alone and to implement this policy by means of an executive order, thus usurping the proper role of the legislative branch. As these examples demonstrate, when faced with opposition from Congress, President Obama has repeatedly sought to go it alone. It is thus all the more necessary and important that Congress continue to exercise its constitutional role and to check this President's abuse of power wherever it sees that occurring.